Okay. This is an updated version of a program I gave here back in 2020. And our idea today is not to focus on all of those things, but rather the emphasis is on the end of life preparation. And this, of course, gets into personal decisions and things that can be done ahead of time to have your ability to the best as the law allows concerning what you want to happen at the end of your life as far as medical treatment and other legal matters. I would point out that on page 2 of the outline, there is a summary in the next several pages about what would be considered a basic estate planning document. That would be a will, a durable power of attorney for finances, a durable power of attorney for health care, an authorization to comply with HIPAA requirements of Medicare, and then a living will. But to get started, let's focus on truly the end of life matters, and that is the living will and what you can do to direct how you want the end of your life, the procedure you want. And first off, an apology. Lawyers generally deal with the negatives. Nobody comes see a lawyer happy. and so those negatives are when things aren't going the way you might want, and it could be other people involved in your family that one has a different view than another, and how the law can help resolve those conflicts. But each of you, I imagine, have had a family member who has faced these decisions, and you as a family member have also faced the decisions and what happens. And I'll tell the story about my own situation where my father died in 1973. It was my final year in law school, my senior year in law school. And he was at St. Luke's Hospital with lung cancer in Kansas City. And the doctors came into me, and it was severe lung cancer, and they don't have the treatments back then. And the doctor said, well, we don't know if we can do anything more for your father, but we need your authority to stop giving treatment. And I was young. Before law school, I had gotten hurt pretty bad in Vietnam. And I said, pull out the stops. Who knows? Miracles happen. And the doctor said, okay. And then 2 hours later, he died. And then later, the doctor and I were talking, and he said, I spoke with your dad several days before his death, and he said, I know you have to ask Mike if you should continue trying to keep me alive, even though you don't think I could stay alive. And I know what he'll say, and I'm telling you, don't do what he says. And so he died peacefully several hours after they talked to me. There were no DNRs, there were no living wills or anything like that. Now, when my mother passed away in 2010, just shy of 101 years old, she died peacefully. She was transferred from the nursing home back to her house, and she died peacefully with hospice there and the way she wanted. And a lot has happened over those years from 1973 to 2010, and certainly more now, especially what can medically be done to keep you alive. And quite frankly, they can keep you artificially alive, even though there's no hope for a considerable period of time. So we're the law is trying to catch up a little bit with medicine on what can be done. Now, the most basic thing is, and this is under Kansas law, is a living will. And it is statutory. Kansas statutes, and this is on the back, I'll give you the page number, the format, straight out of Kansas statute book. It's page 9 of the 10, and then I had some additions. And it says that while you're fully competent, you are stating that if I have an incurable injury, disease, or illness certified to be terminal by 2 physicians who have personally examined me, one of whom shall be my attending physician if possible, and they have determined that my death will occur whether life-sustaining procedures are utilized or where the application of life-sustaining procedures would serve only to artificially prolong the dying process, I direct that the procedures be withheld. And Kansas law requires there be 2 witnesses, and oftentimes there's also a notary on there. And that is the most basic in general and all-encompassing thing that you could do. You can have other things such as do not resuscitate, but this is really the key. And most of the time, that would be coming up in a hospitalization situation. Or it could be you've been in the hospital and you're being transferred to home, like my mother was, for hospice and palliative care, and the doctors in the hospital make that decision before you come home. Or it could be, but not, unfortunately it doesn't happen as often as it should, it could be made at a nursing home. But sometimes there's a lag there where it's not accomplished. But this would be the basic ingredient. Now, the next question is, obviously, the healthcare provider, that be a hospital, nursing home, or whatever, would need a copy of this. And if you don't have one, oftentimes you'll be able to sign one, in the hospital or in the nursing home. But it has to be signed while you're competent. But that's the basic one. Then let's go a step further, and that is durable power of attorneys. And on the very last page, I have an example of the typical durable power of attorney for health care. And you will see on that page what is there at the bottom. It says, decisions concerning artificial life support, medical treatment, surgery, and other medical procedures. In other words, the principal, that is the person, the patient, signing this durable power of attorney for health care is directing that their agent, or sometimes called their attorney in fact, has authority to take care of medical treatment if you're unable to make those decisions. Now, as long as you're able to do that, then it doesn't come into play. But let's say someone would have a stroke, they're taken by EMS to the hospital, they're in a coma or whatever, they can't admit themselves, so the agent has authority to sign the admission papers, also to consent to surgery, and it also says make decisions concerning artificial life support. Well, wait a minute, that conflicts with the living will. And I believe that the way it is universally interpreted is that the living will overrides the DPOA for medical. And so, for instance, one of your children could be named your spouse usually, but if your spouse is predeceased, one of your children would probably be your healthcare agent. And what about they say, well, I get to make decisions concerning artificial life support, and I don't want it stopped. Well, I think the living will, the Kansas statutory format, would take precedent in that case. Now, the abbreviation for durable power of attorneys is DPOA. The key is durable. That means that, for instance, in healthcare, but it also applies a different DPOA for finances, means it survives even if you're declared incapacitated, incompetent. So it would still be in effect. It's durable. So, for instance, used to be that you would have to have a guardian appointed for that person and over their person, and a conservatorship over that for the finances. But the durable power of attorney saves that expense and is effective upon two doctors saying you're incapacitated. Well, it's as far as a healthcare one, it goes into effect immediately. And you're talking about, you could be talking about $2,500 under our procedures in Kansas for a guardianship and conservatorship. So, and that would include the expenses, and also the appointment of a lawyer as a guardian ad litem and other things at a court hearing. So the durable part is very important for medical and also for finances. Now let's talk a little bit about problem areas, and that would be the DNR, do not resuscitate. And Kansas has a specific statute on it, but the statutory one concerns decisions to limit emergency care, and this is one of the attachments. Page would be 10. I don't think it says 10 on the bottom, but at the back of your packet. And this simply says that you are refusing treatment if my heart stops beating or if I stop breathing. No medical procedures to restart breathing or heart functioning will be instituted. No resuscitation will be attempted. Now that's pretty darn specific language, and I can certainly imagine a number of times when probably the patient, probably the person signing this, would not want that, or family members would not want it. So it is something that needs to be taken very careful thought to. And let's take the situation where someone is at home and their spouse is living there, and the ill person has signed this DNRA, and it is posted with a magnet on the refrigerator and possibly in the bedroom. And the husband sees the spouse, or the wife in this case, in bad situation, but not as bad as heart stopping or stopping breathing, calls the EMS, and by the time EMS gets there, they're not breathing. What do you do? And this person, while fully competent, the ill person has stated what they want, and that would not be overridden by the spouse or someone else saying, do not resuscitate. But at the same time, the ill person wants to relieve the family members from making decisions such as that. So it's a careful balance, but it takes time, considerable thought. Now, this DNR that I'm speaking of is emergency medical care, usually arriving with EMS, coming to home, I guess, or wherever, and EMS knows about the DNR. And of course, they might not see it till they get there and see it on the refrigerator door in the bedroom. But these are decisions you have to have take a lot of care of. Now, one thing I want to emphasize is, as long as the patient is competent, they can revoke the living will or the DNR completely. As long, in fact, the law kind of indicates even if they're incompetent, they can override it as long as they say that. So that's, and the same would be true of a healthcare power of attorney. So you would always have the opportunity to change your mind, or it could be EMS is there and you're conscious enough that you can somehow or another communicate to them that you do want treatment, then I'm sure that they would provide that treatment. So those are big decisions, and you can see some conflicts. And like I say, in my practice, I usually deal with the estate plan, putting it together, but when it really comes up in an emergency, that's when people contact the lawyer to find out what to do at that stage. And as you can imagine, what happens if there's a DNR, the person has been in a nursing home and is brought home basically to die, but they don't have a living will, or they don't have the statements of the two doctors that, you know, it's the end and nothing can be done. And hospice is there, and the person is dying naturally, and everybody knows that. And the one of, say, 3 children says, do whatever you can to keep her alive. Don't let her pass away. Don't die. And if EMS came and there is a DNR on the refrigerator door, then that would take care of that situation. They'd let them die naturally. And I think that's what everybody, just like my mother at almost 101, wanted to die under those circumstances. But these are really thoughtful things. You should definitely discuss it with your spouse, and these decisions have to be made, and these legal documents have to be signed while you're fully competent. But at the same time, as long as you're capable, and even if you're hallucinating, if you say no, then no's no. You can revoke it at the last minute. Next thing I'd like to talk about, just for a few minutes, is another very confusing area of the law, and this is something that is handled toward the end of the life, and that is transfer on death deeds. And the law changed in effective July 1st of 2023, just 9 months ago. And you will see on the attachments where I've put in page 8 how these statutes have changed. Now, the problem with this from a legal perspective is it mixes real estate law and probate law. In other words, this statute, KSA 593504, only concerns transfers on death of real estate. And we sometimes call this the poor man's trust, because a lot of times, you know, the most valuable asset, not to a specific beneficiary, is the home. And it transfers on death to the grantee who you name as a beneficiary. Now, if the husband and wife are alive at the time of executing this, often it will say, John and Sally Smith, husband and wife, transfer on the death of the second one of them to die to our 3 children, and names the children. And there was a case in Dickinson County where one of those 3 children predeceased the mother and father. Okay, what happens in that case? Well, under the old law, it lapsed, even though just one of them passed away, because the statute at that time specifically says that if the beneficiary, if the grantee, the children predecease, it lapses. There it is. And so the legislature, and as Marty well knows from the legislature, oftentimes laws are made to apply to all of us over one county having one problem, one person. And so the law was changed when the transfer on death deed was not made contingent on the grantee beneficiaries surviving the record owner and the deceased grantee beneficiary leaves at least one surviving issue, that is children or grandchildren. Upon the death of the owner, such interests which would have otherwise lapsed does not, and goes to that predeceasing beneficiary, their issue, their children. Boy, that's talking like a lawyer. You got to be a Philadelphia lawyer to interpret that. But that is the idea. The general rule is that it would lapse, but in this case it would not. Now, before this new law went into effect, what I always put was if the 3 children, after each name, I would put per stirpes, and that means that it would go to that person's children if one predeceased. But this makes it statutory. And the problem with the old law was that it needed to, to specify that it would go per stirpes, and that's what happens under the new law. It works real good with a situation where it's the parents concerning the home or the surviving parent concerning the home transferring on death in equal shares to the children. And then now the law says if one of those 3 children predeceases, it doesn't go to the other 2. It doesn't void the transfer on death deed, but rather that predeceasing child's share, that 1/3, goes to their children. However, under the old law, I had to give a deposition Wednesday on a situation where there's a transfer on death deed to a non-relative, and it was really kind of part of a business transaction, I believe. It was a TOD, and it was just this named person, and that person predeceased, and according to law, it lapsed. Now, other important things about transfer on death deeds is it has to be recorded with the Register of Deeds prior to the death of the grantor. It has to be. I had a case where I went to an individual's home, and I had known them forever, and he was in extremely bad shape. And he wanted a TOD. He was confident. He signed it. I brought a notary with me, and I was driving back, and he was here in Leavenworth. It wasn't that far from my office. And I said, I better go up right now and record this. And I did, and he died about 10 minutes after I recorded it. So you've got to get it. And I have another case. Boy, I talk about, I had another case where there were properly filled out transfer on death deeds that they got from the Register of Deeds, but they hadn't been recorded, so they were void. Why is that true? Well, because the owner, the grantor, continues to own the property until that grantor dies. So the beneficiary, the grantee, doesn't own anything until that person dies. So if they predecease, then it lapses. This new law kind of makes sense of if there's several beneficiaries or grantees and one of them predeceases, then lapse the whole thing. Now, let's go back. How am I doing on time? One thing I forgot to say about the DNR, the do not resuscitate. Okay, this law states that it must be in writing, signed by the person making the declaration or by another person in the presence of the declarant, dated and signed in the presence of a witness. Now, unlike the living will, it's not two witnesses. It's one witness. And the law goes on to say, of course, that person has to be over 18. And interestingly, and this is getting pretty specific, and the witness shall not be the person who signed the declaration on behalf of the declarant, related to the declarant by blood or marriage, entitled to any portion of the estate of the declarant according to the laws of intestate succession or under any will, or directly financially responsible for declarant's medical care. Boy, we got a lot of legal cases there. Of course, that means that for the DNR to be signed, you can't have the husband or one of the kids be the witness. Just that simple. I presume that the reason they can't have any financial responsibility was they might stop everything because they have a financial gain to make. And also, under a will or intestate succession, they would be getting something when that person passes away. But these are a couple of things to kind of focus on right now. And I believe that Kansas law provides most people with how to get to where they feel they need to get. without too great of an expense. Now, back real quick to the transfer on death deed. A will does not trump a transfer on death deed. A will does not trump the TOD. The TOD trumps the will. And that means that you have a will that leaves everything to one person, but you have a transfer on death deed that was recorded prior to death with the register of deeds for a piece of real estate. It does not go by will. It goes by the transfer on death deed, unless the grantee or beneficiary of the transfer on death deed predeceases and there's not other beneficiaries. Now, if there's just, in other words, you have to opt out of the lapse now if there's more than one grantee. Yes? Sure.
What about, like, if you have a bunch of IRAs and insurance policies and stuff, do you put those in your will?
No, usually, and
Could you restate the question?
yes, I'm sorry. Very good. The question is, what happens with IRAs or life insurance? Because generally the will would say, everything that I got goes to these people. However, and the easiest example is life insurance. Well, life insurance is simply a contract between you and the life insurance company that when you pass away, the policy proceeds go to whoever you name. So it's not part of probate. It's not covered by the will. It's a contract between the insured, you, and the insurance company. So it does not. The next thing is IRAs. And that would not be, generally that would not be covered because IRAs would have a beneficiary. Now, if there's no one named as the beneficiary in an IRA, then the proceeds would go by will to the estate. Or if the primary beneficiary on the IRA predeceases and no one else is named as a secondary beneficiary, then it would go to the estate by will. Generally speaking, we're hesitant to put IRAs into the estate because it would trigger probate. And we're also hesitant on naming a revocable trust as a beneficiary because there can be benefits depending on the relationship in an IRA to stretch out the payments so it's not all taxable at one time. And so those are concerns. Now, actually, the IRS is now pretty well recognizing the 10-year withdrawal part of a spouse. But those are the general rules. Real quick, any other questions? Yes, ma'am. Clay.
It's common belief among hospital personnel that a DNR is suspended for a certain period of time if you have an operation. Because obviously if they give you enough anesthesia, you're going to stop breathing.
Yeah.
Can you comment on what the duration of that is?
Well, of course, the Kansas statute concerns pretty much EMS. emergency care where they're coming to the home. In the hospital setting, I believe that would be under medical. You know, I think the physicians would make those decisions. And it would not trigger the DNR coming into effect. Now, I'll pick on Dr. McAllister real quick. I did hear one comment fairly recently that concerning the Kansas living will, this person had heard that some physicians are too quick to say the person, nothing can be done for that person. And they were worried about two doctors in a living will saying they were terminal and nothing could be done, when in fact that wasn't the case. I've never, I know of no example of that. In fact, to the contrary, I think docs are very careful about those type of situations. And we still see in the living will situation, people coming in living will. Liz and I were talking, and years ago I was on the medical ethics committee at our VA. And that committee was charged with, a lot of times, especially in the old domiciliaries, there were people who were there that came there without any family. Nobody had any indication of where family members were, and they were terminal, and but there was no living will. And what do? Well, if you pull out of the stops, that person could physically suffer while you're doing that. In addition, their life could be prolonged artificially for months and months. And so this committee, we would meet, I believe Liz has been there on that committee too. At least when I was on it years ago, the treating physicians would come before us, and we would examine it and make a decision where, do artificial means just continue indefinitely? And also on the committee was a Catholic priest and a VA social worker, and can't remember right now who else was on it. And we always reach a consensus. Living will takes that away. I mean, if you don't have the living will, you're really putting things in a difficult position. It's one page, not much else. I have got to say, give careful thought to the DNR. Give careful thought to the DNR. I think it can work in almost all cases, but there can be some cases where it doesn't. Same thing goes for that transfer on death deed. It can work well in some cases as an estate planning tool, but in other cases it may not. And the one true saying in estate planning is, know where you're going to land before you jump. You want to know what the end result will be and handle those situations as best you can. Any other questions, real quick? Hey, I got off pretty light. I would urge you to there should be enough of these packets to take with you. And also, I have what I think would be considered a living will that has been for Catholics, that has been approved by the Archdiocese of Kansas. You take one of those. They basically do the same thing. Yes, ma'am.
trust? Do you have a problem with trust?
No. Trust, okay, real quick. Trust, it depends. Well, first off, the key to a revocable living trust is you get everything you own that has a title to it into the trust. Marty and I have a trust, and our checking accounts are in the trust. All the real estate, everything that has a title to it is in the trust. Why? Because you skip probate if everything with a title is in the trust. There's nothing to probate. Sometimes you can handle the situation, though, with transfer on death deeds and named beneficiaries. So, but trusts are good. They skip probate. Probate, another thing about probate is it's public knowledge. You can go down and look at anybody's, it's a court filing. Now, there's always a pour over will that pours over everything that you might have missed that has a title into the trust, but that requires some sort of legal proceeding. One other quick thing, if we got a second. Okay, one other quick thing is Kansas, like I say, is very progressive. I mean, it's not a bad system at all. If there are some things that are could be missed and their total value is less than $75,000, used to be $50,000, July 1st, 2023 went to $75,000, you can transfer that with what we call a small estates affidavit. Problem is, it's Kansas. And I've run into problems with, in particular, computer share on, stock and stuff like that. That is problematic because they don't have to honor it. The next thing is things that have a title or could be problematic. There could be little things. For instance, we have our home insurance with Armed Forces Insurance, but our vehicle insurance with USAA. And I had a heck of a time getting my subscriber's account transferred into the trust. You can do that. What their provisions are is the insured, which is the military person, usually, let's just say it's the man, the husband, it provides that it goes to the spouse upon death of the husband, of the member of USAA. But what about that spouse predeceases, or the spouse owns it and then she passes away? Well, that subscriber account maybe could be handled by the small estates affidavit. It's usually not that big of money, but that is a problem. You got to think of everything that's got a title and try to get it into the trust.